What if you could study the 50 most frequently tested questions on the entire real estate exam? We've analyzed thousands of questions from our LexaWise database to bring you exactly that. I'm Alexei from LexaWise, and in this video, we'll master them together so you can feel confident and prepared.
LexaWise, Real Estate Exam Prep.
The system is very easy. We will read aloud each question with its respective options and let you think for a moment. Afterward, we'll reveal the right answer and break down why it's correct in just a few seconds. Let's get started. How would you define a bilateral contract? A bilateral contract is a contract where a promise by one party is given in exchange for a promise by another party. B, a bilateral contract is a contract where a party is given a promise while the other is not. C, a bilateral contract is a contract that applies only to leases. D, a bilateral contract is a contract where one party is forced to perform. Take a moment to consider. The correct answer is A. A bilateral contract is a contract where a promise by one party is given in exchange for a promise by another party. This works because a bilateral contract is a mutual agreement. Each party agrees to perform something in exchange for the other's commitment. Here's another one. When a family rents a house from January 1st to June 30th, what type of lease agreement is this classified as? A. Tenancy at sufferance. B. Estate for years. C. Tenancy at will. D. Periodic tenancy. Think it through. The correct answer is B. Estate for years. That's because an estate for years always has a fixed start and end date, just like January 1st to June 30th in this case. Next question. What is a listing agreement? A. A legal rental agreement. B. A legal contract between the seller and a broker that establishes their agency or non-agency relationships. C. A legal assignment agreement. D. A legal novation. Pause to decide. The correct answer is B. A legal contract between the seller and a broker that establishes their agency or non-agency relationships. This is the formal document that spells out how the broker represents the seller and the terms of that relationship. Here's one about surveys. What is a property survey in real estate? A. A search of public records to determine the ownership and legal status of a property. B. A search of the property's physical condition to identify any defects or issues. C. A map or drawing that shows the boundaries and features of a property. D. An assessment of the market value of a property. Take a second to choose. The correct answer is C. A map or drawing that shows the boundaries and features of a property. That's because a property survey clearly outlines the legal limits and improvements on the property. It's used to avoid disputes and confirm boundary lines. Let's keep it going. What is an easement in real estate? A legal document that transfers ownership of a property from the seller to the buyer. B. The right to use a portion of another person's property for a specific purpose. C. An assessment of the market value of a property. D. A contract between the buyer and seller that outlines the terms of the sale. Think it over. The correct answer is B. The right to use a portion of another person's property for a specific purpose. Easements allow one party to use another's property, like for access roads or utility lines, without owning it. Let's work through this scenario. What is the purpose of title insurance in a real estate transaction? A. To protect the buyer and lender against defects in the title of the property. B. To guarantee that the property is free of all liens and encumbrances. C. To provide coverage for any future property damage or loss. D. To ensure that the property is in compliance with local zoning and land use regulations. Take a second to decide. The correct answer is A. To protect the buyer and lender against defects in the title of the property. Title insurance exists to guard against unknown issues like liens or claims that could affect ownership after closing. Here's a situation you might see on the test. Broker David obtained the right to purchase a commercial acreage property within 90 days and also took a listing for the property. If he decides to exercise his right to purchase the property on the 87th day of the listing, what must he do before buying the property? A. Provide information about any pending or received offers from potential buyers. B. Disclose any relevant details or significant facts to the owner. C. Get written permission from the owner, recognizing any profit or anticipated profit. D. All of the other answers are correct. Think this one through carefully. The correct answer is D. All of the other answers are correct. When a broker holds both a listing and a purchase right, they must disclose all offers, get written consent from the owner, and share any material facts before exercising the option to buy. Let's tackle this next. If the liquidated damages clause is initialed in a real estate purchase contract and the buyer defaults, what should happen to the deposit? A. It should be given to the seller when escrow is opened. B. The deposit should be 2% of the sale price or the amount of the deposit, whichever is less. C. It should be utilized to cover liquidated damages for both the seller and listing broker. D. The deposit should be utilized to cover any escrow-related costs, and the remaining amount should be refunded to the buyer. Take a moment. The correct answer is C. It should be utilized to cover liquidated damages for both the seller and listing broker. If the buyer fails to fulfill their obligations and the liquidated damages clause is initialed, the deposit should be applied to compensate for any losses incurred by the seller and the listing agent after accounting for any relevant expenses. Here's a quick one on contract terms. The terms valuable, good, sufficient, and adequate are most closely associated with which contractual concept? A. Consideration. B. Performance. C. Bilateral contracts. D. Compensation. Pause to decide. The correct answer is A. Consideration. These terms describe the value exchanged in a contract, something both parties offer as part of the agreement. Next question up. Real estate listings are required to be in writing by A. Statute of Limitations, B. NARCADA, D. Statute of Frauds. Think it over. The correct answer is D. Statute of Frauds. The Statute of Frauds requires that certain agreements like listing contracts must be in writing to be legally enforceable. Let's take a look at this one. An option contract A results in a commission to the broker if the optionee does not exercise the option. B gives the buyer a lien on the property. C keeps an offer open for a specified period of time. D requires the optionee to complete the purchase. Think about it carefully. The correct answer is C, keeps an offer open for a specified period of time. An option contract allows the potential buyer to purchase the property at a set price within a set time frame, but they're not required to follow through unless they choose to. Here's one you don't want to miss. Which of the following results in automatically terminating an offer to purchase real estate? A. Rejection of the offer by the offeree. B. Rejection of the offer by the offerors. C. A request made by the offeree to the offerer inquiring if they would be willing to accept alternative terms. D. Revocation of the offer by the offeree. Take a second to decide. The correct answer is A. Rejection of the offer by the offeree. Once the offeree rejects an offer, that offer is terminated. Unlike a counteroffer or inquiry, a rejection ends it completely. Here's another. Lucas gave Will an option for the purchase of Lucas' property. In law, such an option is regarded as A. An offer to be part of a contract. B. A contract to keep the offer open. C. An involuntary lien on the real property. D. An agreement that is similar to the relationship between a buyer and a seller in a land contract. Think it through. The correct answer is B. A contract to keep the offer open. An option is a binding agreement that locks in the offer for a period of time. The seller must honor the offer if the buyer chooses to act within the agreed period. Let's move on. When does a voidable contract stop being binding on the parties involved? A. When the contract is invalidated. B. When the contract is rescinded. C. When the contract is qualified. D. When the contract is discovered. Think it over. The correct answer is B. When the contract is rescinded. A voidable contract is legally valid until one party with the right to cancel it chooses to rescind it. Here's a question on commission rights. In which of the following types of listings is the owner still obligated to pay a commission, even if they sell the property without the help of the broker? A. Open listing. B. Net listing. C. Exclusive right to sell listing. D. Exclusive agency listing. Take a moment to decide. The correct answer is C. Exclusive right to sell listing. This type of listing gives the broker full rights to the commission, no matter who sells the property, even if the owner finds the buyer themselves. Let's move on. What does the term voidable contract mean? A. It means that the contract is not legally binding for either party involved and cannot be validated through ratification. B. It means that the contract has no force or effect. C. It means that the contract is valid now but can be voided by an interested party for due cause. D. It means that the contract is open to disciplinary measures. Think this through. The correct answer is C. It means that the contract is valid now but can be voided by an interested party for due cause. Voidable contracts are valid and enforceable until the party with legal grounds chooses to cancel them. Next up. If Patrick intends to hire Southridge Real Estate Firm to aid him in finding a buyer for his house, but also has a friend named Carla who may be interested in purchasing the property, which type of listing agreement permits him to sell the house to Carla without incurring a commission fee? A. Exclusive authorization and right to sell listing agreement. B. Open listing. C. Residential listing agreement, seller reserved. D. Option to buy listing agreement. Pause to consider. The correct answer is C. Residential listing agreement, seller reserved. This agreement allows the broker to represent the property while still giving the seller the right to find their own buyer like Carla and avoid paying a commission. Here's one more. At what stage does Monica's offer, accompanied by a check, become a binding contract to purchase the home her agent, Neil, showed her? A. When the deposit check clears. B. When Monica is notified the seller accepts the offer. C. When Neil receives her offer and her check. D. When the seller receives the offer and the check. Think it through. The correct answer is B. When Monica is notified, the seller accepts the offer. There are typically four essential elements to form a legally enforceable contract: capable parties, legal object, offer and acceptance, and consideration. The offer and acceptance aspect usually involves three steps: offer, acceptance, and notification of acceptance. Let's move on. What kind of interest is typically paid for the use of money borrowed on home loans? A. Simple interest. B. Discount interest. C. Compound interest. D. Annuity interest. Take a second to reflect. The correct answer is A. Simple interest. Home loans usually charge simple interest, which is calculated based on the loan amount and does not compound. Let's look at this one. Can a homeowner who is selling their own property legally advertise the down payment as part of the sale? A. No, because it is prohibited by RESPA. B. Yes, if it was listed only with a broker. C. No, because Regulation Z prohibits it and violates consumer credit protection laws. D. Yes, because it is his own home. Think it over. The correct answer is D. Yes, because it is his own home. A private homeowner is allowed to advertise terms like the down payment when selling their own property. These rules primarily regulate professionals, not individuals acting on their own. Next up, which regulation requires mortgage loan originators to provide borrowers with a closing disclosure at least 3 business days before the closing of a real estate loan transaction? A. TILA RESPA Integrated Disclosure TRIT. B. Equal Credit Opportunity Act, ECOA. C. Truth in Lending Act. D. Fair Housing Act. Take a second to decide. The correct answer is A. TILARESPA Integrated Disclosure. TRID. TRID ensures borrowers receive accurate and timely loan cost information through the closing disclosure, giving them time to review before closing. Here's a question about mortgage insurance. Which entities are authorized to provide insurance for a mortgage loan? A. DVA Department of Veterans Affairs. B. FNMA Fannie Mae. C. GNMA Ginnie Mae. D. FH, a Federal Housing Administration or private mortgage insurer. Think this through carefully. The correct answer is D. FHA, Federal Housing Administration or private mortgage insurer. Mortgage insurance can be issued by a government agency like FHA or by a private company, depending on the loan type and borrower qualifications. Now let's move on. Under the Truth in Lending Act, who is responsible for informing consumers about the terms of credit? A. The lender. B. The trustee. C. Escrow. D. The broker. Think it through. The correct answer is A. The lender. It's the lender's legal duty to provide clear, written disclosure of credit terms so borrowers can make informed decisions. Let's take a look at VA loans. Among the following options, which one is responsible for providing the financing for the Department of Veterans Affairs VA loans? A. Approved lenders. B. HUD. C. The secondary mortgage market. D. Freddie Mac. Pause to consider. The correct answer is A. Approved lenders. The VA guarantees part of the loan, but the funds themselves come from private lenders who are VA approved. Let's go over this one. What rights does a borrower have if they fall 3 months behind in their trust deed payments? A. The borrower has the right of refinance. B. The borrower has the right of reinstatement. C. The borrower has no rights and will lose the property. D. The borrower has the right of redemption. Think this one through. The correct answer is B. The borrower has the right of reinstatement. That's because the borrower can catch up on missed payments and applicable fees to avoid foreclosure. This is called the right of reinstatement and is usually built into the terms of the trust deed. Now here's another. An example of a cost associated with owning a home is A. Land appreciation. B. Appreciation of improvements. C. Amenity value. D. Loss of interest on an owner's equity. Take a moment to decide. The correct answer is D. Loss of interest on an owner's equity. This refers to the opportunity cost the homeowner isn't earning interest elsewhere because their money is tied up in the property. Here's one you'll want to remember. Promissory notes are A. Used as security for trust deeds. B. Always used when real estate is sold. C. The evidence of the debt. D. Recorded at the county recorder's office. Think it over. The correct answer is C. The evidence of the debt. That's because a promissory note is the written agreement where the borrower acknowledges the debt and promises to repay it under agreed terms. Let's take a look at this one. What does a release clause in a mortgage do? A. Creates a lien that is subordinate only to the lien of taxes and assessments. B. Allows the borrower or lender to extend the due date of the loan. C. Releases a guarantor from additional responsibility under certain terms. D. Allows parts of the property to be freed from the mortgage lien. after a certain action is performed. Think carefully. The correct answer is D. Allows parts of the property to be freed from the mortgage lien after a certain action is performed. This clause lets portions of the property be released from the lien, often after a set amount of the loan is paid common in subdivisions or lot sales. Here's another question. What is the percentage basis on which discount points are calculated? A. The loan amount. B. The loan amount plus closing costs. C. The selling price of the property. D. The selling price plus the agent's commission. Think it through. The correct answer is A. The loan amount. Discount points are prepaid interest, and each point equals 1% of the loan, not the purchase price. Here's a good one. Sometimes, a broker may earn a commission by demonstrating that they initiated a sequence of events that led to the sale of a property. If a broker brings forward a buyer who is prepared, willing, and able to purchase the property, then the broker would probably A. Have secured the buyer's signature on the sales contract. B. Have an exclusive right to sell listing. C. Have showed the property to the buyer. D. Be considered the procuring cause of the sale. Take a moment to reflect. The correct answer is D. Be considered the procuring cause of the sale. Why? Because when a broker sets in motion the series of events that result in a sale, they've effectively earned the commission under the principle of procuring cause. Let's keep going. A potential buyer may be eligible to receive damages from the broker if a real estate broker does which of the following? A. Create a contract on behalf of the seller with proper authorization through a power of attorney. B. Turn the earnest money deposit over to the seller and then the contract falls through, no fault of the agent. C. Provide inaccurate information based on what was received from the seller who employs them. D. Act in excess of the authority given to the broker by the seller. Think this one through. The correct answer is D. Act in excess of the authority given to the broker by the seller. That's because if a broker exceeds their granted authority, they may be liable for damages caused by their unauthorized actions. Here's another. The crucial element in establishing an enforceable broker-principal relationship between two parties regarding a right, title, or interest in real property would be A. An employment contract. B. The authority to accept a deposit. C. A purchase agreement. D. An agreement about the commission. Think it over carefully. The correct answer is A. An employment contract. That's the formal agreement that creates the agency relationship and authorizes the broker to act on the principal's behalf. Next up, while completing the coursework for his real estate license, Mark assisted his neighbor in selling his house and was promised a 5% commission. Mark successfully found a buyer and the transaction closed 2 days after he received his license. However, the neighbor is now refusing to pay Mark the agreed upon commission. Does Mark have grounds to sue for damages? No. To be eligible for any compensation, Mark must have been licensed at the time of the agreement. B. Yes. Even though Mark was not licensed at the time of the agreement, he accepted an unsolicited offer from his neighbor, which is binding under contract law, but not real estate law. C. No. Solely authorized brokerage firms have the ability to file a lawsuit against individuals for commission. D. Yes. Since Mark held a valid license when the transaction concluded. Take a second. The correct answer is A. No. To be eligible for any compensation, Mark must have been licensed at the time of the agreement. To legally earn a commission, a person must be licensed at the time the agreement is made, not just at the time of closing. Let's go over broker compensation. Typically, the commission amount for a broker is A. Established based on standard industry rates, which are regulated by the Sherman antitrust law. B. Established by agreement between the broker and the seller or the buyer. C. Established by the Real Estate Commission. D. 5% or 10% for a single family residence, depending on the area. Think carefully. The correct answer is B, established by agreement between the broker and the seller or the buyer. That's because real estate commissions are negotiable, they are not fixed or regulated by law. Let's review this one. Upon signing a contract and becoming the buyer's agent, the licensee should inform all other parties with a vested interest in the transaction: A, after the offer is accepted; B, after the close of escrow; C, after the licensee has received the commission; D, as soon as possible. Take a second to consider. The correct answer is D, as soon as possible. Disclosure of agency relationships must be made promptly to ensure all parties know who represents whom. This helps avoid conflicts and maintains transparency. Here's one more. The person to whom a real estate agent provides advice and guidance is referred to as the A, broker; B, client; C, customer; D, subagent. Pause to decide. The correct answer is B, client. A client is the person the agent owes fiduciary duties to, like loyalty, obedience, and full disclosure. Next one. Which of the following mortgage broker advertisements would the real estate commissioner prohibit? A, we loan upon verification of equity. B, loans up to 60% of verified market value. C, first trust deeds offered at a 15% APR. D, dial 1-800 for a loan. Think this through. The correct answer is D, dial 1-800 for a loan. That ad implies a loan can be approved over the phone without proper qualification. Such statements are considered misleading and prohibited by regulations. Now let's take a look at this one. Which of the following options does not terminate an agency relationship? A, the property burning down. B, the broker's suspicious performance. C, lack of performance by the seller. D, the owner canceling the listing in order to contact the potential buyer and sell to him or her directly. Think it through. The correct answer is D, the owner canceling the listing in order to contact the potential buyer and sell to him or her directly. A seller can't terminate an agency just to avoid paying a commission. The relationship still exists until properly concluded or expired. Here's one on types of estates. What is a freehold estate? A, a freehold estate is temporary in nature and can be terminated by the owner at any time. B, a freehold estate is a type of leasehold estate that grants the tenant ownership rights. C, a freehold estate is an estate in which the property is owned outright and without any time limitations. D, a freehold estate is a type of tenancy in which the tenant is only entitled to possession of the property and not ownership. Take a moment. The correct answer is C. A freehold estate is an estate in which the property is owned outright and without any time limitations. Unlike leasehold estates, a freehold estate implies permanent ownership either for life or indefinitely. Let's keep going. The zoning of a vacant lot was changed from commercial to residential by the authorities through proper action. What is the term used to refer to this type of action? A, retroactive zoning. B, down zoning. C, spot zoning. And D, blended zoning. Think it over. The correct answer is B, down zoning. We call it down zoning when land is rezoned for a less intensive use, like from commercial to residential. Here's another. Is it within the state's authority to obtain a portion of privately owned agricultural land for constructing a highway as it is intended for public use? A, no. Under the US Constitution, state or federal governments may never acquire private property. B, yes. The state's right is called eminent domain. C, yes, the state's right is called condemnation. D, yes, the state's right is called escheat. Take a second. The correct answer is B, yes, the state's right is called eminent domain. Eminent domain allows governments to take private property for public use, but they must pay just compensation. Now let's look at this one. During periods of high inflation, a property manager would typically negotiate A. Net lease, B. Land lease, C. Indexed lease, D. Fixed lease. Think carefully. The correct answer is C. Indexed lease. Why? Because an indexed lease adjusts the rent based on inflation, helping the landlord keep up with rising costs. Next, here's one more. Which of the following actions can terminate a lease? A. Refinancing. B. Expiration of the lease. C. The sale of the building. D. Abandonment by the tenant. Pause to decide. The correct answer is B. Expiration of the lease. Only the natural expiration of the lease term automatically ends the agreement. Refinancing or selling the property doesn't do that. Let's move on. The type of estate that a tenant would receive from a landlord is A. Tenancy at sufferance. B. Life estate. C. Fee. Simple, absolute. D. Leasehold estate. Think this one through. The correct answer is D. Leasehold estate. Leasehold estates give tenants the right to occupy the property for a set time but not ownership. Next, what is the primary responsibility of a county assessor? A. Determine the tax rate that will be assessed by property owners. B. Determine the percentage of the assessed value that property owners will pay in taxes. C. Assign parcel numbers to new developments for the purposes of assessing and recording property taxes. D. Determine the amount of tax to be paid by property owners. Think it through. The correct answer is D. Determine the amount of tax to be paid by property owners. This is because the assessor evaluates property values, which local governments use to calculate tax bills. Now, another question. What is a real estate investment trust, REIT? A publicly traded company that invests in a portfolio of real estate assets and distributes a portion of its profits to shareholders as dividends. B. A privately held company that invests in a single real estate asset, such as a commercial building or residential complex. C. An investment vehicle that allows investors to pool funds to purchase a portfolio of real estate assets. D. A government agency that provides financing for real estate development projects. Take a second. The correct answer is A. A publicly traded company that invests in a portfolio of real estate assets and distributes a portion of its profits to shareholders as dividends. REITs allow everyday investors to buy into income-producing real estate while receiving dividends as part of the structure. Here's one about listing agreements. An example of a specific type of exclusive agency listing is A. Seller option listing agreement. B. Multiple listing agreement. C. Residential listing agreement. D. Residential listing agreement. Seller reserved. Pause to decide. The correct answer is D. Residential listing agreement seller reserved. This type of listing gives the broker exclusive marketing rights, but the seller can still find a buyer independently without paying commission. Let's move on. Which statement about land sale contracts is accurate? A. The buyer's responsibility to pay property taxes usually does not arise until the seller has delivered a deed for the property. B. The land sale contract is similar to a lease in that the buyer had a right of possession but no rights in the title. C. The seller retains equitable title until the buyer pays the loan in full. D. Land sale contracts are the least secure method of financing for the buyer because the seller retains the title and the buyer is merely the equitable owner. Think this one through. The correct answer is D. Land sale contracts are the least secure method of financing for the buyer because the seller retains the title and the buyer is merely the equitable owner. The buyer doesn't receive legal title until the full contract is satisfied, which puts more risk on the buyer. We're almost done. Which of the following actions would not result in a broker's license being suspended or revoked? A. Placing a for sale sign on a neighbor's property without obtaining the owner's permission, even if the neighbor has informed the person that the property will soon be listed for sale. B. Being officially deemed mentally incompetent by an acknowledged agency or authority. C. Accepting earnest money from a buyer and depositing it directly into a trust account. D. Revealing a buyer's race to a seller. Think it through. The correct answer is C. Accepting earnest money from a buyer and depositing it directly into a trust account. That's actually the correct procedure. Earnest money must go into a trust account, and doing so is fully compliant with license law. Here is the last one. After a foreclosure sale resulting from a mortgage default, what is the right that a mortgagor retains? A. Reinstatement. B. Redemption. C. Non-foreclosure. D. Estoppel. Do you know the answer? If you said option B, you're right. Redemption refers to the right of the mortgagor to reclaim their property by paying off the outstanding mortgage balance and any associated fees within a certain time frame after the foreclosure sale. This right of redemption can provide a last chance for the mortgagor to keep their property, although it may come with additional costs and restrictions. You made it to the end. Congratulations. Thank you for staying. We hope you feel more confident now for your real estate exam. If you like the video and find it helpful, please don't forget to leave a like and subscribe. There are many more topics to explore. If you need to keep practicing, check out LexaWise Exam Prep. The link is in the description below. Keep studying smart, and I'll see you in the next video.